Welcome to Lawyer in Layman Explained. This is a show where we discuss topics related to law and social justice from the perspective of a layperson who is much more qualified to argue about college football rules than any legal topic, and
someone who reads the terms and conditions when I sign up for gym classes or at the dentist or kind of most places in my life. And I'm telling you, these places are never ready when I start actually reading the form. Before we dive into our episode, quick disclaimer. This podcast is for educational purposes only and is not intended to provide any legal advice. If you need legal advice, you might want to pause this podcast and find a lawyer.
Then come back. Please come back.
Any inaccuracies are unintentional, and facts could change at any time. Do your own research.
Now, before we get into it, I want to show you some love for always reading the terms and conditions. I feel like it's such a trope that people do not read those, and I don't. However, since we've been together, I definitely pretend to skim over some contracts that I sign now. Not that it's going to change. I feel like, that's a whole other episode, T's and C's, because you're either going to sign and accept or not. And
yeah.
What are you going to do? Slip them back? You know what? Actually, here's my revised T's.
Here's my counter offer. For I don't know, whatever, Orange Theory or whatever, Jim. Yeah, it's funny you say that because the listeners who went to law school with me and who were in my section will know that our contracts professor, in addition to flipping her little bang every class, was very adamant that she was like, stop playing games. You know we don't read these. We move about our lives, we go about our things. We're not reading these things. So I appreciated her practical approach, even though she didn't really teach me the contracts I needed to know for the law school, for the bar exam. But in any event, and yes, to your point, going about and reading these forms, people's eyes get big. And in fact, they're like, well, no, I'll tell you what it says. And I'm like, well, no, but I can read and I prefer to read. And they're like, oh, okay. So yeah, it's definitely not a thing that a lot of people do. But, and I'll be honest, what am I going to do? Not take the class if I don't like what's in there? So yeah, it's a thing, but it's not a thing.
Right, like when you update software, or I think of Apple's T's and C's, no, there's a semi, a kind of viral example of Disney's T's and C's in the last couple of months, I think.
Yes.
Which, tying back to my little intro, college football season, you're signing up for streaming services. Who knows? You might.
Oh my goodness.
Yeah.
What have we signed up for? What have we signed away?
Well, that's definitely a whole other episode, and I can't wait till we get into it. So back to today's episode. This is actually a part 2. So in the last episode, we shared some basic and fun facts, depending on your definition of fun, about the Supreme Court of the United States. You're listening to part 2 of Supreme Court 101. So if you haven't listened to part 1, we suggest pushing pause and going back to listen. Or you could be completely chaotic and listen to this episode first. It's your life. Up to you.
So at the end of the last episode, we were talking about why exactly it is that court opinions are hundreds of pages long and not, for example, a page long, just cutting to the chase. The idea that the people who have gotten these fancy legal degrees and worked in fancy legal places, being the ones who are making these decisions, are probably not going to write one-page opinions, both because the things before them are super important, but also because they're like, well, I have this immense vocabulary and awareness of cases, and I need to walk the reader through all of that. But let's make things a little more tangible and walk through an example together. Listeners can even follow along if you're in a place to do so. So not driving, that would be a terrible idea. Martin, can you please pull up the link to Alexander versus South Carolina that I am about to send to you? While Martin is pulling up the Supreme Court opinion, I'll remind listeners to listen to episode 2 if you haven't yet, where we talk about the Alexander case in detail. Today, we're just going to be talking about how the opinion is structured. All right. Thank you, Martin. So, what is the very first word you see at the top?
Syllabus.
Great. Can you read the note text?
Sure. Note, where it is feasible, a syllabus, head note, will be released as is being done in connection with this case at the time the opinion is issued. The syllabus constitutes no part of the opinion of the court, but has been prepared by the reporter of decisions for the convenience of the reader. See United States versus Detroit Timber and Lumber Com. 200 US 321337.
Pop quiz. What's the 200?
Pop quiz hot shot. That's a speed reference for any listeners.
Who doesn't love Keanu?
The 200. That's my weak Keanu impression. That might get cut. I can do a better one. Whoa, I am an FBI agent. Okay. I just had to get
Listeners can vote as to whether or how much Martin sounded like Keanu Reeves.
Back to a question here. 200 references the physical location of the document.
Which volume of the U.S. Reporter? So pretty close. Yes, in the series of many U.S. Report volumes, the one that's labeled 200 is going to contain this opinion. And then what's the 3 to 1 mean?
We just talked about this. I forget.
When you open up the reporter, how would you know?
What page?
Yes, exactly. Perfect. No, it's all good. That's why we rehearse, because these things are not intuitive. When I read my first court opinion in law school, and I was like, that's what all those gobbledygook numbers and letters mean? What? Wild. So the syllabus is basically a summary prepared for the case, and it's not written by the court. It's written by someone with the title reporter of decisions. That's their job, to report on decisions and also write this syllabus. So it's some text that appears in opinion that's actually not written by the court. All right. Then you have the full case name. Martin, can you read the case name for us?
Alexander, president of the South Carolina Senate et al. Versus South Carolina State Conference of the NAACP et al.
Perfect. So,
what does et al. Stand for again? I know it's like everyone. I know it's like, and it's kind of like, etc., etc., etc.
I'm so glad you asked that. That was next up in my notes. That's perfect. So et al. It's Latin, but it's short for another Latin abbreviation to not make things complicated at all. But in any event, it means and others. So here it means there were more individuals or entities than listed that were part of both parties in this case. So the plaintiff had more than just the first person who was named, and the defendant group had more. And I am recognizing that I'm using plaintiff and defendant, and that's not the terminology that's used in the Supreme Court. But in the lower court where the case was initially filed, there was a plaintiff and defendant. There's different language, as we mentioned, appellant and appellee.
There's a lot of questions here, actually. I don't know how deep we want to go into some of this stuff.
You can ask, and there's some things I won't know, and I will either look it up or I will ask somebody who does know. But hit me. What do you got?
So how do they decide who is like the representative out of the et al?
That's an excellent question, and I don't know. So I'm going to only speculate here, but I don't know. So we're going to need to do our own research, and listeners will need to do the same. But in this instance, it seemed as though the Alexander person, the person who was the president of the South Carolina Senate, was the one who was maybe in charge of or doing most of the action that was being complained about. Because if you remember, when we were talking about the Alexander case, the case was actually filed by the NAACP. So the names here are reversed, but the plaintiff originally was the NAACP. And so I imagine that Alexander is the person that is would primarily be held responsible. And then the South Carolina State Conference of the NAACP, NAACP for short, is the main party that advanced the claims, but not the only plaintiff, not the only member of the plaintiff group. So there were others that joined in the plaintiff's group.
Yeah, my guess would be it's like,
I'm guessing.
Yeah, my guess would have been like for essentially like marketing purposes. So like you get the biggest name, deepest pockets, but also like leadership and responsibility also makes sense. Like if he's the leader of an organization, which is the South Carolina Senate, like it kind of makes sense to put the president up there if they're one of the major parties. It's interesting, yeah. And then you also answered my part two is like the order. because I imagine that matters. I bet you like there's also like conversations with the judge, I'd imagine, right? Like of who's what case is what. Because also there's like aggregated cases from the Supreme Court, right? Where they like take multiple courses or multiple cases that have a similar issue at hand and like join them or bring them together,
Yes.
and then like one name takes precedent. And I'm sure that's like a discussion with the parties themselves and the judge, and
So you,
some complicated, like drawn out process unnecessarily, or you know.
so that process of consolidating cases, bringing multiple cases into a sort of single action or single header, I there was some of that at the federal district court level when I was clerking, but I can't speak to exactly what the process is because, as I very briefly touched on, the Supreme Court has a series of rules, as most courts do, and so there's probably a rule for consolidation. I'm not sure in this case or in the broader Supreme Court context if consolidation is like a parties file a motion to consolidate to bring together related cases so that one ruling is going to apply to all of them, or if the judge, the court decides, hey, we're going to bring these related cases together. It is something worth us looking into.
I'd imagine it's probably like a relational decision, right? Like and I would imagine the court, they really have final say of
The court
everything,
would,
right?
the court would, but I'm not sure it's something that they would do of their own volition, or if they would, if parties would, because I mean, a lot of things wouldn't happen unless parties filed a motion or filed a lawsuit to begin with. So it's something for us to look into. And again, if any of our listeners know the answer, please do reach out to us. Any other questions before we proceed?
We can go ahead and get back on.
No, these were great questions, though. Thank you for asking. Can you read the line under the case name?
Yeah. Appeal from the United States District Court for the District of South Carolina.
Great. So that gives you some history about where the case came from before it got to the Supreme Court, some of the appeals history. Can you also read the next line?
Number 22-807, argued October 11, 2023, decided May 23, 2024.
So the 22-807 is the number assigned to the case. I'm going to assume the 22 represents the year that the Supreme Court agreed to take the case, but I'll admit I was lazy and didn't look that part up. / I wanted a reason to tell our listeners to do your own research. And then the dates are interesting. It gives you a glimpse into how long the court took to get to this opinion. So now this circles back to what we talked about before, right? Like, when in the term does an opinion come out versus when was it argued? We can maybe guess, right? And there's probably some information out there that would help us solidify our guess, but we can probably guess it took them a while because there was a number of things that made this case complicated, controversial, but they decided it toward the end of their term. Any thoughts on that, Martin?
No, I think you kind of touched on all my observations, that this one took like 7 months, almost the entire term. What's interesting, and it's actually really helpful, I think, to understand just like what these different pieces are, because even without a walkthrough, if you look at the document, there's a whole lot of words.
Yes.
Different sizes.
Right.
Different, formatting. A lot of all caps that starts to look rough on the eyes.
Yelling, screaming. Yes.
Yeah.
Now I'll ask you to scroll to the page that says opinion of the court on it.
All right. Just like I said, there's a lot of words. It's interesting that
this is just the syllabus.
Right. And it's interesting that the syllabus is written to aid the reader. And I'm looking at this, I'm like, I'm not reading this.
Skip. Next. Perfect. So now we're out of the syllabus and into the content written by the court. Can you read the line that's under the date?
Justice Alito delivered the opinion of the court.
So that part is self-explanatory. It tells you who wrote the majority, or if it applied. It doesn't apply in this instance, but who wrote the unanimous opinion. So this is the opinion that's going to come first, and it's going to have the justice's name who delivered the opinion that becomes law, becomes precedent. There are Roman numerals throughout to represent different sections of the opinion. Usually section 1 includes the decision of the court. Martin, can you scroll down to where section 1 is about to end. Can you read that last sentence of section 1?
We therefore reverse the trial court in part and remand for further proceedings.
So reverse means to overturn the prior court's opinion, and remand means to send the case back to be retried in accordance with the new precedent. So, Martin, what do you think will happen? Even not knowing the details, you know some of them from our last episode, of course, but without knowing the details, this is just an example of a case. What do you think will happen after a decision like this now that you know there's a reverse and remand?
Yeah, it's interesting the mechanics of this. The Supreme Court offers a decision, but they say essentially you didn't do it right. Here's how to do it. Now go do it. And it's interesting that it puts the onus on the lower court to affirm this decision that they clearly didn't agree with in the first place, because otherwise it wouldn't have been appealed. Yeah, it's just kind of interesting.
You're raising good points. It's sort of interesting to think about being in the position of a lower court who's getting this opinion, and they're also doing their jobs and trying or hearing, in the instance of appeals courts, hearing arguments on other cases, right? So they're going about their regular judge and court work, and then they get this opinion that says, you did not do the right thing, try again, and read 104 pages to get you to the right place. It is sort of interesting that we kind of end up in this position sometimes, not all the time. There's multiple sort of outcomes for a Supreme Court case, and this is just one of them. So here, Section 2A covers a lot of the prior cases that the court claims it relied on to reach its decision. These are the cases that are either on point for the topic itself or the factors that a court should consider when addressing the topic. And I'm greatly oversimplifying the sort of content that's in this section, in part because I don't want to get into a lot of legalese, and in part because of time. But that's sort of a high-level summary of Section 2A. And then Section 2B here covers the facts that were presented to the prior courts. So these are known as the facts in the record. For the most part, courts, even the Supreme Court, are supposed to consider only the facts in the record as they reach their decision.
Just the facts, man.
Yeah. So that's not always the case. We'll talk about that in another episode. But I mean, when you think about it, right, like aside from all the politics we know that surround the current Supreme Court justices, judges are human beings. They all come from somewhere, some background, some experience. It seems wild to imagine that they could truly be a body that's only considering the facts in the record and not other sort of
right
things that exist, right? But that's the mandate of being in a court, including the Supreme Court. Any thoughts, those you're thinking about these sections of the opinion?
No, I would concur with you on the last part. Ideally we would hope that these well-educated, supposedly tested lawyers, people who've been practicing judges, having these strong backgrounds, are able to hold themselves to a high standard and be somewhat impartial and determine the facts. That's also, I think, an interesting part of court cases is like this control of information and what can be considered and how do you consider it, and all of those things. But it's interesting, even the Supreme Court tries to define its focus very narrowly, which feels right. Like it really should be these limited cases, and it should be these very focused, defined decisions, which I'm sure is all that happens.
Another topic we'll get into in another episode. Section 3 gets into the court's analysis and why they decided what they decided, or rather how the majority reached its opinion. This section, the court's analysis, is usually the longest section. We're not going to go over all of this by any means, but Martin, I want to ask you to read the last paragraph before subsection A.
Section 3, subsection A. The last paragraph before.
Yes, correct.
Wait, last paragraph or last sentence?
Correct. Yep,
okay.
You got it.
We divide our analysis into 4 parts. First, we set out the appropriate legal standard for reviewing a district court's factual findings in racial gerrymandering cases. Second, we explain why the district court's factual findings are clearly flawed with respect to the challenger's circumstantial evidence. Third, we examine the 4 expert reports that the challengers presented below. And finally, we explain that the district court erred by not drawing an adverse inference from the challenger's failure to submit an alternative map that would have allowed the state to achieve its districting goals while maintaining a higher BVAP in District 1.
So, Martin, without paying attention to the substance of the paragraph, just thinking about sort of how it's laid out, what are your thoughts?
It really feels like a smackdown. It's like we have these 4 things. First, we did this. Second, they didn't do this right. Third, like they didn't have any style. Like it's just like
they didn't have any style. So this is where Martin gives lawyers, including myself, a reality check of when you give a 4-part signpost and you think you're being so helpful, you actually sound like you're just trying to give all these reasons why the other side is wrong. So yeah, I looked at it and I thought, wow, what a helpful preview of what's in the analysis. And you're like, did you really need to give 4 this and this, and you didn't have style? So also kind of just speaks to, who the expectant audience of this is, because one person could read just this paragraph and take away like, wow, you had to go in on them 4 different ways. And then another person would be like, okay, like I know what 4 things to expect.
Yeah, I mean, putting on my Reddit lawyer hat, I would again concur. But I can see how it kind of tells a story. It says not only does it divide it into 4 parts, but they're kind of chronologically. It said first we did this, second we did this, third, and then finally this is how we found our decision, which I guess is helpful. Like in me to the layman, I'm like, up and just tell me. Like, whereas I, from the legal perspective, from a lawyer's perspective, it would make sense that it's very specific and prescriptive as to what they decided and how. Because I'm sure, like, as we talk about the Supreme Court kind of having these like narrowed focus and supposed to have very clear decisions. The reason being because things can probably apply in different contexts or in different times or with slightly different circumstances, and then have that brought up. So having this very clear analysis and storytelling, I think, helps hopefully inform other courts, other lawyers to how to interpret
the
law.
And again, for our listeners, we're not getting into the substance and content of the opinion. We do that in the prior episode and in a prior episode. And we are not saying that the decision reached in this opinion is the one that we believe is the right decision. But we're talking about the structure of a case so that you all can be more informed about how they are organized and how to better understand them if you decide to read one. So finally, section 4 of the majority opinion, or the main opinion of the court, goes into why the Supreme Court thinks that the lower court got it wrong. So Martin, if you wouldn't mind scrolling to section 4.
Scrolling.
It's quite a lot to scroll through.
Goodness, I should probably just go to the side. Do you know what page it's on?
Oh, good question. I don't.
Let's just jump over here because this is a 104-page decision. I have no idea. Actually,
you're too far. Yeah, you're, because there are 3 different parts to this opinion, right? So it's try looking for. Let's see.
I guess IV comes
Try
up.
searching. It is so. Stealing some thunder here, but yes. Okay. So we have reached section 4. And in this section, the Justice Alito, in this case, who delivered this opinion, describes why the prior court got it wrong. Martin, can you read the very last words, the ones in italics?
This is from Alito?
Yes, this is the same opinion.
Do I have to read these words? I guess for the purposes of the podcast. I'm just kidding.
Just the part in italics.
Okay, just the. I was gonna do my voice, but
Oh gosh.
it is so ordered.
4 words. I mean, that is the Supreme Court opinion of a mic drop.
Yeah, that's the slapping around thing that I was judging from above. That's the real mic drop, as you put it.
But we're not done yet. Scroll down a page, please.
Oh my gosh. I was actually shook. I started scrolling. I was like, wait a minute.
Yeah, you're not even like a third of the way of the document.
Yeah,
it is quite the lengthy document. So sometimes cases have what's called a concurrence. And I think of this, there's probably a better definition, but I think of this as there's a judge or multiple that agrees in part or in whole with the conclusion of the majority opinion, but they would have gotten to the outcome differently. So, Martin, I'm going to ask you to read the line after the date.
Justice Thomas concurring in part.
I'm also going to ask you to read the very next sentence.
I join all but part 3C of the court's opinion.
Great. And there's so much to this. There's a lot of words that are written, but basically, Justice Thomas wrote the concurrence and decided not to join Justice Alito's opinion to point out what he did not agree with in the majority opinion, in Justice Alito's opinion. Do you remember in very high level terms what happened in part 3 of Justice Alito's opinion? That was the one that was the longest.
It was something about
Section 3, I should say.
Something about something that was like pivotal to the measurement of the standard of whether the states needed pre-clearance.
Sorry, I did not mean to make the question so complicated. So when we were walking through the sections, and my question was not phrased correctly. We were walking through the sections, and section 1 was the one that had the sort of let you know what the decision of the court was. And then section 2 was laying out all the cases and then facts. And then section 3 was the court's
summary of
basically, yeah, their analysis, like all the details. It's the longest section because it's all of the sort of substance of why it is that they reached the conclusion they reached. So there's a specific part in part 3, in section 3, excuse me, that Justice Thomas is saying that he disagrees with, and that's why he wrote the concurring opinion. The concurring opinion has its own structure, and we're not going to spend a ton of time on it, but want listeners to know that there are cases that have this nuance of having a concurrence. Not every case has one, or for that matter, not every case has a dissent, because there are such things as unanimous decisions, which would have neither. But wanted you to get a feel for there's this other piece that could exist that's not saying I completely disagree, saying I disagree with some part, and I'm willing to write my own whole opinion to talk about the thing that I don't agree with that the main opinion focuses on. We're not going to go through this concurrence though for a number of reasons. Not just because of the justice who has pinned it, but for other reasons. We're not going to go through the concurrence. Martin, instead I'm going to have you scroll to page 70 in the PDF. These opinions are long, right?
So long. Okay.
You're on page 70? Great. Can I have you read the line after the date?
Justice Kagan, with whom Justice Sotomayor and Justice Jackson join, dissenting.
So here we have 3 judges saying that they do not agree with the decision of the main opinion. And like the majority opinion and concurrence, the dissent has its own structure with sections. As much as I'd love to get into the dissent because the judges drop some serious bars in it, we're focused only on the layout of a case. So Martin, you have reached the end of this exercise, painful as it was. We started from the syllabus, we made it through the dissenting opinion-ish because we did not dive in any level of depth. Any reactions after this exercise? Does this make you want to go like immediately read 104-page opinion like this?
This kind of makes me a little glad that I'm a law nerd and not a lawyer. That was grueling. Like
Yes.
that, like even just like taking apart the piece. Like, not gonna lie, scrolling through those pages, I was like, dang, this is a lot. Yeah, it's interesting. It looks like really tough work, but it also makes sense for the highest court.
And when you think about it, granted, if I was in that position, I might not necessarily spend the 35 words of one of the opinions or the cumulative 104, but these are cases ultimately that affect people's lives, right? Their ability to access or not access certain things, etc. And so I could imagine, although I don't know for sure, but I can imagine that Supreme Court justices may put a lot of pen to paper given the significance of these cases that come before them.
Yeah, ideally, these are extremely important cases, and therefore they need to be detailed. There needs to be a lot of work and reasoning behind them. That, again, ideally would make sense.
So we talked a lot already about the court as an institution. We're going to switch gears ever so slightly and talk about the judges themselves. And we're back into Jeopardy style questions. Martin, for 200, what are the people on the Supreme Court called?
What are justices?
You know, I'm going to give you, I'll give you the 200.
Associate justices and chief justice? I
Wait
think
a
that's what
minute.
you're looking for.
Okay. Nicely done. You get the 200 points. So I was
really
going to give you,
Jeopardy,
I was going to give you the,
it on the second buzzer, but
I mean, I'm maybe a nicer, host.
you're Ken and thus Alex. That's a deep
Sure,
cut
but
for all the
I have
Jeopardy
seen
nerds.
Ken do some savage moves that I'm like, really,
Oh yeah, that's true. Yeah.
really,
Yeah, that is.
like that person said the correct answer, phrased in the correct form of a question, but digression. So I'm giving you the 200 points. I would have accepted the first answer because I don't know that your average lay person would know the associate or chief part on top. But yes, justices, great. Each person on the Supreme Court is an associate justice except for one, who is the chief justice. And I know Martin is probably chomping at the bit to go through the members of the Supreme Court, but we're going to do that in an upcoming episode. I do have another question for you, though. How does a person become the chief justice? Any guesses?
Ooh,
And again, the chief justice.
yeah, I'm guessing, is it like a vote, like internal to the court? I'm not. Dang, that's a good question. I actually don't know. Yeah.
I don't think I knew before researching for the podcast either, because I generally knew the process for justices generally, associate justices generally, but not the chief. It didn't ring a bell. The answer is that they have to be nominated by the president and confirmed by the Senate, like the associate judges. But keep this in mind. A person can occupy the role of chief without having been an associate justice first. There have been 17 chief justices in the history of the court, and only 5 were associate justices before transitioning to chief justice.
Wow.
Did you know any of this?
None of that. That is mind blown. And it's, when you said only 5 were associate justices, I thought it was going to be the opposite. And I was going to say that's even too many. Like, how do you get onto the highest court and then you get the chief justice? That's pretty wild.
We can talk more about historically who the chief justices have been and surmise and speculate how they got there. But again, fodder for another episode.
I'm like, can the president like change chief justices and keep one on the court? That's fascinating. Maybe that's a question for further research.
Yes, I would like to look into that / invite listeners who know to let us know. I don't know offhand. But can I ask you another question?
Yes.
How does someone get onto the Supreme Court?
I think the last answer is the same, right? There is nominated by the president and then has to pass congressional vote. I'm going to leave my answer at that and not get any more specific, because I think the Senate confirms, the House votes on who's in Senate confirms or something like that, but it's a congressional vote. I'll take my points.
This one was not a Jeopardy style because there's maybe some different parts to it that might not naturally fall into an answer. You're generally aware of the process, but I will ask you to read the language from the Supreme Court's website.
The President nominates someone for a vacancy on the court, and the Senate votes to confirm the nominee, which requires a simple majority. In this way, both the executive and legislative branches of the federal government have a voice in the composition of the Supreme Court.
That short paragraph just sounds so simple and easy, but it is an extremely messy, political, and complicated process. Are you surprised at all by that, Mark?
Not at all. It's also interesting that it's a Senate vote and not doesn't involve the House at all, which is interesting. But yeah, that's surprising. I think I've known about it, and then especially I think in our lifetime there's been 6 or 8 appointees to the Supreme Court.
That's a really good point. We could put that data together pretty quickly. I don't know that I could put it together offhand. That's a pretty solid guess. I've got another question for you, Martin. And this one, I think you might find it interesting. Does a person have to be a lawyer or attend law school to be on the Supreme Court? What do you think?
I don't think so. I think this is set up. I feel like I've read this on the internet before, but also set up to be right for a no. You know, it can be anyone, I think.
Well, you are correct. According to the Supreme Court's FAQ page, there's no constitutional requirement that a member of the Supreme Court be a lawyer or go to law school. In fact, the FAQ says the Constitution does not specify qualifications for justices, such as age, education, profession, or native-born citizenship. So a 17-year-old who has not graduated from high school sounds like could be a Supreme Court justice. I don't know. So far, all of the members of the Supreme Court have had some legal training. But I wonder, aside from my joke about a 17-year-old who sounds like probably a terrible candidate for the Supreme Court, but do you think that the practice of us continuing to have only legally trained justices on the court should continue? Like, how do you think things would change if it was actually a requirement that one person on the court be somebody who didn't receive legal training? Maybe, a teacher or an engineer, somebody who approached life differently than somebody who had legal training. What do you think?
Yeah, that's interesting. I think as a layman, yeah, sure, maybe I could advocate for that. I do think it's interesting because in so many ways, our government advocates for representation, right? It needs to, of the people, by the people, for the people, whatever order you so choose. So, I mean, I think it would be interesting to have a normal person on the Supreme Court because there's only so many people who, like, realistically, I think in practice could make it to the court. At the same time, heck no. Like, I feel like you should have a basic understanding of the law and prove that, which I think, the debates on the bar and what law school actually teaches people. But I think this is one area where I think there is a strong argument to be made for tradition or like upholding that tradition that there's some sort of requirement. It honestly, I mean, I think given some of the most recent appointments, it seems like there should be some very strict qualifications. Like, I don't know, having good ratings with ABA, having argued in front of the court, or having experience somehow interacting with the court, or as a judge for a certain amount of years. There, it feels like there should be some pretty high qualifications for the highest court in the country.
So I was going to make a ploy to the listeners to join me in making a petition for our host Martin to get on to the Supreme Court, but it sounds like
God,
he would
no.
not be that thrilled with that.
I would enjoy an RV, I will say that, and lavish vacations. So maybe you're onto something here.
Except I think you would be the type of person who would reject such gifts, or at least declare them, maybe. Martin's pausing and thinking.
For the purposes of the podcast, yes, absolutely. I have upstanding ethics and morals, and I've never accept lavish gifts unless they're made legal in the form of like gratuities after a decision.
Yes.
And, hey, it's legal. That's totally fine, right? But come on, that would never happen.
Next question for you. How long do justices get to stay on the Supreme Court?
Forever.
And why?
forever and ever. Which I think is built in. It's supposed to dissuade justices from being influenced, and part of having political influence of force upon them too.
So you've got the answer, and I am also want you to read some language from the Supreme Court's website that may give us a little more context, if you don't mind.
The Constitution states that justices, quote, shall hold their offices during good behavior, end quote. This means that the justices hold office as long as they choose and can only be removed from office by impeachment.
Thoughts? I mean, you gave us some initial thoughts, but seeing this new language, what do you think?
I have a ton of thoughts. Of course, good behavior. Wow, that is a low bar. That's not like crimes and misdemeanors. That is good behavior. That's so interesting. And as we referenced earlier in this conversation about the Supreme Court, I think it's like we talked about earlier in the conversation about the Supreme Court and like kind of the basics. It's a for interpretation. They wrote this in the Constitution, whatever good behavior means, and then it's up for us to interpret how to apply that and agree on how we execute the application.
It's certainly a topic that we will spend more time on because there's a lot that a person can accomplish in a career lifetime. So in the several decades that many people, including justices, work or serve, some good things and some things that can be harmful. So certainly worth revisiting. And as you know, Martin, there's some organizations that would advocate for term limits. What are your thoughts on that?
Honestly, despite it kind of becoming a more loud part of the conversation and what's going on with the Supreme Court, I feel like I haven't devoted much time to thinking about that. On the one hand, I think it would be, I mean, it only makes sense. People can only do certain things for certain periods of time, and that's not to discount older folks or people who've been doing something for a long time, but you build up these blind spots in addition to just it's father time. It's our humanity. We become less sharp as we age. We become less possible, or less, I don't know, productive and capable. And I think spending that much time in a role will sever that connection you have with the average person. I can imagine very many Supreme Court justices who did not live a comfortable life because of where they reach in their career. And when that happens, you lose touch with the average person, despite having this huge influence on their lives.
It's very well said. And listeners, we'd love to know what you think on term limits or how long that justices get to occupy their seats on the Supreme Court. The last question I have in my script, Martin, you may know the answer to this, so I'm very curious. It's not Jeopardy style, but I'm curious how you'll respond. Why do the Supreme Court justices wear black robes?
Yeah, that's an interesting one. I feel like all judges wear black robes. It's got to be like some tradition or something like that.
I'll invite you to read the language from the Supreme Court's website. You're touching on a lot of what's explained, but please read it for us.
Judicial robes have long been thought to bring dignity and solemnity to judicial proceedings. Following the custom of English judges, some American colonial judges adopted the wearing of robes along with many other customs and principles of the English common law system. When the Supreme Court first met in 1790, the justices had not settled on whether to wear robes, but in February 1792, they did appear in a standard set of robes for the first time, which one report referred to as, quote, robes of justice. These robes are thought to have been black, trimmed with red and white on the front sleeves. They were only used for a few years before the justices adopted all black robes.
Martin, are you aware of Justice Ruth Bader Ginsburg's collars by chance?
sounds vaguely familiar. I imagine she wore colors as forms of like protest or messaging.
She had a really wide variety of collars, and she did have ones that were known as her dissenting collar, or ones that made certain statements.
Hmm.
But there are entire works that are devoted just to the collars that Justice Ruth Bader Ginsburg put on top of her robe. So there
Hmm.
are things that justices maybe do to sort of, get
Express
flashy,
themselves. Hmm.
add a little flavor to the uniform. And it's funny because it reminds me of when I went to uniform school in junior high. Very similar to being on the Supreme Court, except not. And I hated having to wear the white or blue, navy blue, or forest green top, and then blue or khaki bottoms as the only fashion choice available that I had to me. And I got crazy with my socks, and I was known as having crazy socks. And I was like, yeah, rebelling against the system. So that was something that I feel like added some flavor to my uniform. And it's kind of cool to know that the Supreme Court justices are adding a little pizzazz to their black robes. But what are your thoughts on this whole outfit thing for the justices?
That's amazing. I knew that you had an affinity for like interesting colored socks. I never heard their origin story before, so that's super cool to piece that together, and it's really cool. It's a very cute story. To let some of your personality show. Yeah, I think it's interesting. My first thought was we need the the menswear commentator guy from Twitter to weigh in on the judges and the history of all that stuff. Casey's not chronically online like I am, so I don't know if she gets it. But if you're on Twitter, you know who I'm talking about. Yeah, it's interesting that they a little pizzazz. Like the original robes trimmed with red and white on the front and sleeves. I'm trying to picture that. And
Me too. Yeah, I'm having a hard time picturing it. And like, what is the trim? Is it some stitching? Is it ribbon? Like, what is the extent of the trim? I
right,
don't.
I imagine it's like a thin like piece of like kind of color, and because it's red and white, it makes me think of like candy cane stripes. And I just cannot take someone seriously. And I'm just imagining this old timey dude, from the late 18th century, and he's wearing a black robe that looks so serious, but then he has these like silly, like, I don't know, there's just some weird vibes coming from that. It definitely does not express the dignity and solemnity that what was in the quote. Um, yeah, that's interesting. It makes sense that it's adopted from English common law because that's where a lot of our law comes from too. I
Right.
mean, a lot of what our
Exactly.
the colonial culture was
Mhm.
from, England, despite being rebelling against them. Fascinating history.
Yes.
Who knew the judges had such a deep fashion or deep tie to fashion?
So that concludes the questions that I have for you, Martin. And I want to know, because you are a layperson, you may have questions. Are there any other questions you have? We can see what we can find out together.
I think we did. I think you did a really good job of covering like some of the basics of the court, and there was just so much to cover here in such a small medium. I think it'd be hard to do, but I think we covered a lot of the basics, like the makeup of the court, and it was really cool to even dive into an opinion and kind of how it's broken up. I am curious, like how do cases get in front of the Supreme Court? Like, how does it make its way up? Like, I understand there are appeals courts, and there's probably a set amount of layers and stuff, but it's interesting how do things end up in front of the Supreme Court?
You raise a great question that is also covered in the Supreme Court's FAQ document, and highly recommend that listeners take a look at the FAQ page if you haven't already. There's so much more information beyond what we've covered today. So, Martin's question was, how does a case get before the Supreme Court? Is that correct? Did I understand
Yeah. Uh-huh.
that question correctly? Okay. Let's see. I think I saw a question that was along those lines. It's taking a while for me to find. So if I can't find it now, we'll
I'm
include in our references.
trying to think of any other questions that I might have, but I feel like I'm a little zonked out with all the.
It was a lot of information. So thank you for indulging. And also, thank you for playing Jeopardy ish. I have been keeping track of the score. So out of the 800 possible points Martin gets, let me go back and tally. Martin gets. I'll let you all play the music inside your head because I don't know that we can afford to play it as background music. 500 points. And this score entitles you to the layperson with the most curiosity about Supreme Court factoids award.
I am honored for this award. It's a lot of hard work. I did zero prep for this episode. First of all, I'd like to thank God, thank my wife Casey for being my podcast host, co-host. What about Final Jeopardy? Because I would like to wager all 500 of my points. And
I do have a question for Final Jeopardy. Okay. So Final Jeopardy is it? Oh, I'm thinking Double Jeopardy. Wait, so is it going to be a Double Jeopardy, Final Jeopardy, or wait? Can I just make an arbitrary point value, or?
In Final Jeopardy, me and the competitors would wager, and then we'd get the question.
Yes.
The answer.
Yes, right. Mm-hmm. Okay, I'm ready. I'm going completely off the cuff here, so I hope there's only one answer to this question. And if there are others, I guess we'll do our own research and find out. But the question is, I'm not supposed to be using questions because of how Jeopardy works. I have seen the show, I promise. One of the most common, if not the most common, nicknames for the Supreme Court.
I'm assuming it's not the Supremes. Most common / widely used.
There's not normally this level of dialogue during Final Jeopardy, but I'll allow clarifying questions. One of the most common, if not the most common nicknames, some might say acronyms, for the Supreme Court.
I think you just gave an answer away, but what is SC? Supreme Court? I don't think
Final Jeopardy round is not going well.
That would have been my answer unless you said except acronym.
This Final Jeopardy round is not going how I had envisioned, and I didn't even know that we'd have Final Jeopardy. The answer was SCOTUS, Supreme Court of the United States.
Yeah, I knew that. Dang, it's a miss.
But you still get the award. The award has already been bestowed upon you. Factoids, curiosity, etc. So, great job, Martin. So, I'll leave listeners with one call to action, which is to read a Supreme Court case. Get a feel for what the judges care about, how they refer to other decisions, and what arguments they find persuasive or not. And of course, let us know what other questions you have about the Supreme Court or other topics you'd like us to cover.
That's all for today's episode. Thanks everyone for tuning in. Check us out at Lawyer and Layman Pod on Instagram and Lawyer and Layman pretty much everywhere else. Let us know if there are any topics you'd like us to talk about. Don't walk around not knowing.